It is 7 in the morning. You have been traveling for 14 hours. You are drained. Your luggage is heavy, and all you want to do is get past the airport and head home. You approach the CBP officer at the counter. You hand your passport under the glass, and everything seems routine. Then the officer glances at his screen. He does not return your passport back. He types something. He picks up a phone. And then he says those 4 words that make your pulse freeze. Please come with me. You are escorted to a room in the back. The door shuts. Another officer sits across from you and he pulls your file on his screen. He looks at you and says, I need to review 5 years of bank records. And in that instant, you understand you have nothing. You have no paperwork. You have no documents printed out. You do not even understand why he is requesting. And while you are sitting there attempting to determine what to respond, the clock is already ticking on a procedure that could conclude with you on a plane back to your home nation before the sun sets down with a 5-year prohibition stamped in your record and no hearing, no judge, and no second opportunity. This is not a scenario. This is occurring to real visa holders and green card holders right now at airports and land crossings across the United States. And if you do not understand exactly why it is occurring and exactly what to do, you are at genuine risk. Let me explain what most people get disastrously wrong in this situation, because this is where the snare is. And it is a snare that has already cost thousands of people their standing, their professions, and their lives in America. When a CBP officer requests financial documents at the border, most people do one of 3 responses. They freeze and start speaking too much, offering information they should never have shared. They grow confrontational, which the officer interprets as suspicious behavior. Or they provide nothing helpful because they simply never prepared, never imagined this could happen to them, and believed that holding a valid visa meant that the difficult part was finished. All 3 of these reactions can speed up the path to what is known as an Expedited Removal Order. And if you receive one of those, your circumstances change instantly and severely. Under an Expedited Removal Order, or ERO, you are refused entry to the United States on the spot. Your visa is voided immediately. You are booked on a direct flight out of the country, generally within 24 to 48 hours, and you are prohibited from re-entering the United States for 5 years. There is no immigration judge. There is no court proceeding. There is no appeal mechanism in the traditional sense. The officer who interviews you is also the officer who issues the order. According to legal analysis published by the Murthy law firm and supported by CBP's own operational guidelines, this process is entirely legal, entirely in effect right now, and entirely applicable to H-1B workers, F-1 students, B-1 and B-2 visitors, green card holders returning from overseas, and practically every other immigration category you can imagine. The outcome rests on the CBP officer's assessment in that moment in that room that you are inadmissible. So the issue is not whether this could happen to you. The issue is whether you are ready. Now let me provide you the legal framework you need to comprehend, because understanding is your safeguard. Under the Immigration and Nationality Act, specifically under Section 212, a person requesting admission to the United States must establish that they are not inadmissible on any of the enumerated grounds. One of those grounds found in Section 2112A4 is the public charge provision. This means that if a CBP officer has cause to suspect you cannot sustain yourself financially while in the United States, or that you are likely to become primarily reliant on the government for assistance, that officer can deem you inadmissible. Financial records, including bank statements, are one of the primary instruments CBP uses to assess your capacity to support yourself. This is not recent legislation, but what is recent is how forcefully and extensively it is now being implemented. Since January 20th, 2025, the current administration's executive instructions have substantially broadened the enforcement approach of CBP and ICE at ports of entry. Officers are now functioning under specific guidance to perform more comprehensive financial and biographical screening during admissions interviews, especially during secondary inspection. And because of the biometric entry-exit final regulation that went into effect on December 26, 2025, Every non-US citizen's face is now compared against government databases the instant they approach a CBP counter. If that comparison reveals any flag in your record, any inconsistency, any gap, any previous immigration concern, the probability of secondary inspection increases up significantly. In secondary inspection, the officer has wider authority, more time, and more resources. And under CBP Directive 334049A, they can lawfully examine every app on your phone, including your banking apps, payment apps, and any financial information that is accessible on the device. This is the landscape you are stepping into every single time you cross a US border. Right now, here is where I need to pause and correct something that is circulating like wildfire on social media, on TikTok, and in WhatsApp immigration channels, because it is harmful and it is incorrect. There is a rumor spreading right now that claims CBP has no authority to question you about your finances, that only USCIS can determine financial eligibility, and that requesting bank statements at the border is an unlawful overreach. This is entirely untrue. CBP has complete statutory authority under the INA and under DHS regulations to assess financial admissibility at the port of entry. There is another assertion making rounds that states if you have a valid visa, you cannot be turned away for financial reasons. Also untrue. A visa is an authorization to travel to the United States to request admission. It is not a promise of entry. The CBP officer at the port of entry makes the ultimate admissibility decision, and that officer is not constrained by the decision of the consular officer who granted your visa. I have noticed people in comment threads advising others that they can simply decline to answer financial questions by invoking the Fifth Amendment protection against self-incrimination. As a non-citizen requesting admission at the border, you do not possess the same Fifth Amendment safeguards as someone already inside the country facing criminal charges. Declining to cooperate with a CBP admissions interview is in reality treated as a failure to demonstrate admissibility, and that failure can and does lead to denial of entry. These misconceptions are not just incorrect, they are harmful. Acting on that guidance can land you in an expedited removal order within hours. Now let me provide you the action plan, because this is the section that will truly safeguard you. Tonight, after you view this video, here is precisely what you need to do. First, gather your bank statements from the last 5 years right now. Sign into your bank's online platform. Download your monthly statements going back 60 months and store them in a clearly organized folder, both on your device and in a cloud storage service you can reach from anywhere. If you bank with several institutions, do this for every account. When a CBP officer requests you to prove financial stability, you want to be able to present a clear, consistent financial record. You want to display regular income deposits. You want to demonstrate that your balance is sufficient for your planned stay, and you want to exhibit no questionable large cash movements in and out of the account. If your statement records show irregular trends, get ahead of that by creating a simple written explanation for your files. Second, print and bring a physical copy of your most recent 3 months of statements every time you fly internationally. Yes, physically printed. CBP officers have established authority to inspect your phone, but they cannot require you to unlock cloud accounts or remote servers. Having tangible documents available signals that you expected the question, that you have nothing to conceal, and that you are a well-prepared, organized traveler. That alone shifts the dynamic of the encounter. Third, know your admissibility standing before you travel. Sign into your I-94 record at the official CBP website, which is i94.cbp.dhs.gov, and verify that your previous entries and exits are correctly documented. If you notice any inconsistencies, resolve them before your next international journey, not during a secondary inspection when it is too late. If you have ever exceeded a visa duration, had a prior deportation, or had any problem at a US border, consult with an immigration attorney before you travel. These indicators will surface in the CBP system the moment your biometrics are captured. And an ill-prepared traveller with a flag in their record is precisely the profile that gets directed to the back room. Fourth, if you are a lawful permanent resident, meaning you possess a green card and you travel internationally, you need to bring evidence of your connections to the United States in physical form every time you cross the border. This means your most recent tax return or tax transcript, your employment documents or pay stubs from the past year, evidence of your US residence, such as utility bills or lease agreements, and preferably a letter from your employer verifying your current position. Green card holders can be directed to secondary inspection just like any other traveller. And in secondary, the matter of whether your residence in the United States is truly continuous can arise. Bank statements from a US-based account displaying consistent US transactions over multiple years are one of the most compelling pieces of evidence you can provide. Fifth, if you are ever placed in secondary inspection and a CBP officer starts asking detailed financial questions, here is precisely what to state and how to express it. Be composed, be straightforward. Do not over-elaborate. If the officer asks where you work, you state plainly, "I am employed by," and you give the name of your employer and your job title. If the officer asks about your finances, you say, "I have my bank records available if you would like to review them," and you present the physical copies you organized. If the officer asks a question you honestly do not comprehend, it is entirely appropriate to say, "I want to ensure I understand the question accurately. Could you please rephrase?" You are not being avoidant. You are being accurate. What you should never do is offer information that was not requested because in a high-pressure secondary inspection, additional information almost always generates more questions, not fewer. Sixth, and this is vital, if you are given any document during a secondary inspection, whether it is a sworn declaration, a summary of the discussion, or any form with your name and case number on it, retain every single copy. These papers are the basis of any future legal examination, any request for reconsideration, or any waiver submission. According to recommendations from immigration law practices, including Murphy law and Verdon law, mistakes and misunderstandings by CBP officers do occur, and a documented record of what was actually stated is crucial if you need to dispute a determination. My name is Lisa. I am a senior immigration researcher with 6 years of experience, and on Future Bridge USA, I do not share opinions. I give you the survival approaches that keep families together. What you just learned is not designed to alarm you. It is designed to equip you, because the border landscape in 2026 is the most intense it has been in over a generation. And the people who navigate it without complications are not the ones with the most costly attorneys or the most influential visas. They are the ones who arrived fully prepared. Immigration regulations shift overnight. Join my WhatsApp community for immediate alerts before I publish on YouTube. The link is in the description below, and I want you in that group before your next journey. As a note, everything discussed in this video represents confirmed information as of March 24th, 2026, based on official CBP, DHS, and INA structures, as well as commentary from Murphy Law, the American Immigration Council, and the National Immigration Law Center. This material is for educational purposes only. It is not legal counsel. For your individual situation, please consult a licensed immigration attorney. Policy modifications can and do happen. Always check with official sources before you travel. If this video assisted you, like it right now and share it with every visa holder and green card holder you know. It could be the most valuable thing they watch this year. If you want precise, timely, and trustworthy immigration updates, subscribe to Future Bridge USA right now and activate all notifications. Remaining informed is no longer a choice. It is necessary. I am Lisa. Safeguard your status. Safeguard your family.